Welcome to the 44th episode of The Smartest People in the Room. If you've been following this series, I know, wow is right. If you've been following this series, you understand what we are doing, shining a light on incredibly smart, accomplished people and sharing stories from their careers and lives, as well as anecdotes about their past, present, and future. Today, I am pleased to welcome back one old friend and a brand new friend. Both of these are incredibly talented and respected in their fields of law and legal scholarship, and I promise you will leave this session smarter than you arrived. Before we get started, let me take care of some business. First, to the audience, please feel free to introduce yourselves in the chat window. The reason we do these webinars is twofold. First, we want to showcase really smart people and the amazing work they do day to day in the industry. But the second reason is a bit more nuanced. Most of you know that I am a music industry headhunter. By definition and function, I help people connect with companies. In this series, my goal is to help you make more connections, and I invite you to take full advantage of that opportunity. Specifically, I invite you to engage with the speakers and the other attendees in the chat of the Zoom. Please introduce yourselves, say hello to your friends, and make some new ones. And ask questions of our speakers. We will try to address as many of those questions along the way. And also, please make sure your chat is set to address the speakers and attendees, not just the speakers. I want to thank our program sponsors for their help, for without it, we couldn't do what we do. I want to thank First Horizon Bank, Bufkin Baker, Four Roses Bourbon, the Fairlane Hotel, the Tennessee Entertainment Commission, Lightning 100, Tennessee Brew Works, Moo TV, Jive Printing, Project Music, and Cushmaster's brand of CBD products. So let's get down to business. Today's host is Kevin Casini. We welcome Kevin back for his third journey with us, and I'm very excited to have him. Kevin's an attorney in New Haven, Connecticut, where he's recognized by New England super lawyers for his work in litigation, copyright, and trademarks. His consulting company, Echo Artist Services, maintains a talented client roster of artists, writers, producers, and DJs, and he teaches copyright, music law, and entertainment law at Quinnipiac University of Law. Kevin's a member of the Recording Academy, Music Business Association, the Copyright Alliance, the Americana Music Association, and serves on the nominating committee of the Boston Music Awards and the board of CT Folk, a 30-year-old folk and roots music festival held each summer in New Haven, Connecticut. He and his wife live in Worcester Square, New Haven, with their twin toddlers. Welcome back, Kevin.
Thanks, Tom.
And joining Kevin today as our featured guest is Alex Roberts. Alex is a professor of the University of New Hampshire School of Law. She teaches and writes in areas of trademark and false advertising law, entertainment law, contracts, and law and literature. Her current scholarship focuses on trademark use and distinctiveness generally, and how trademarks function on social media in particular. Professor Roberts holds an AB from Dartmouth College, an AM from Stanford University, and a JD from Yale Law School. She previously served as executive director of the Franklin Peace Center for Intellectual Property, and prior to entering academia, she was an associate in the Intellectual Property Litigation Group at Ropes and Gray. Please welcome these two amazing guests to the smartest people in the room. Take it away, guys.
Thank you, Tom. Thanks, everybody, for joining. In keeping with the gratitude, I want to thank Professor Roberts. I've been bugging her online for a couple of years now, and I'm really, really excited to have her here because myself and a lot of people that are going to join us today, we talk a lot about licensing, we talk a ton about copyrights, but we don't talk a lot about trademark licensing. And one of the conversations she and I hope to get into is something that we hashed out probably earlier this year about a band named Kerfuffle. But before then, I just want to start by lining up some differences that we've got between trademarks and copyrights, and then we'll talk about some best practices, I hope. So as the expert in the room, as I tell Tom and everybody else, you provide the smartest person, and that's you. I'll provide the room. I usually come from an interesting venue, but today, because of COVID, I'm in an uninteresting venue, my den. And so I've been thinking a lot about how to make this one a little bit different. And so I've got my Sharpie and I've got my legal pad. I'm going to be taking notes along with everybody else today. You're providing free services. So take us through, you teach at UNH Law. What would you tell your students, and how do you explain to them the purpose of the trademark? What role does it serve, and what role would it serve in the music industry?
Sure, that's a great big question, right? So a trademark is anything that functions as a source indicator, right? It can be a word, it can be a phrase, it can be a logo, it can even be some kind of packaging or design or restaurant configuration, and anything like that, right? Anything that communicates to consumers that it's an indicator of source. It's going to be consistent. It's going to come from one place. So once you have that, what can you do with it? We call it a receptacle for goodwill. So that means once you have that, once you figure out what it's going to be, you can invest in it, right? You can put a lot of energy and effort into marketing, into reaching consumers, into kind of building a brand. And that's where it goes, and it becomes something really valuable. An important thing to know about trademarks, and we'll talk about this more, I think, in connection with some of those stories that we'll get into, is that trademark rights arise out of use. So if you choose a word, a phrase, a name, something like that, and you start to use it in connection with the sale of specific goods or services, and consumers come to know you as the provider of those things, or they come to know, Colgate as a brand of toothpaste, those rights accrue without you having to take any action. So you could just do nothing and be a trademark owner. If it's a kind of random made up mark, kind of arbitrary or fanciful mark, then those rights arise immediately. If it's something more descriptive, then you have to do a little more work. You have to use it for a while. You have to make sure consumers really understand it as a trademark. But you also can register your rights. You can apply for state or federal. Usually federal registration is going to be the strongest. And that will give you a whole bunch more bells and whistles, and happy to talk more about the reasons to do that and to think about that. In the music industry in particular, it's really, again, something you can build your brand on, something you can kind of use to market yourself to the world and make yourself into a name, build that reputation. And in some cases, it's going to be synonymous with your identity, right? If you're a singer, if you're a solo artist, and you either choose a stage name or you go by the name that your parents gave you that's on your birth certificate, then what you're building is your own brand kind of as a person. Whereas if you're part of a group, if you have a band with a name, or maybe if you're a rapper with a name that's really obviously not your given name, then there's something else going on that looks a little bit more like a traditional trademark. But either way, it lets you put others on notice so that they don't choose the same name or the same mark and start performing under the same name that you're using. It lets you kind of claim that territory, build on it in terms of merchandising and marketing. And in some cases, it's something that you might want to police. So you might want to start looking around and see, is somebody else using something that's confusingly similar, something that I want to reach out to them and say, hey, maybe you didn't realize because we're working in different genres or we're doing slightly different things, but actually I have exclusive rights to use this particular mark in this particular industry.
Or maybe you didn't realize because you didn't look or didn't look hard enough.
Or maybe you knew, but you didn't care, Kevin.
But we'll get there. So you laid out there a ton of stuff for people, and I think two really interesting distinctions. One, copyrights and copyright registration can't be done at a state and local level, right? There's no structure at the state level to accept a registration or recognize existence of a copyright. But in trademark law, although the Lanham Act is federal law, it purposely lists in there that you can have a trademark through the operation of your business and that goodwill, whether you've registered at the state level or not registered at all. You don't need registration at all to have the trademark and to enforce the trademark, which is an interesting distinction, because as we know now, after Supreme Court a couple of years ago, to enforce a copyright, you've got to have completed that registration process. Not so with trademarks.
Right.
But the creation, I think, is the most interesting distinction for me, because modern day copyrights are created instantaneously. I've just created one in sketching out my notes here for today's session. but nobody else knows about it except me. And the trademark works as like the other side of that coin. So maybe you can flesh that out a little bit for people so they understand the consumer hive mind aspect of it.
Sorry, I got a little distracted with the chat. So flesh out the way that trademark rights are created.
Yeah, and how it's instead of an insular or singular event, it really requires that hive mind collectivity.
Yeah, so one of the super fun things about trademark law is that it is whatever you, the people, think it is, right? So if you're kind of watching the news and there's all this crazy election litigation going on, stuff like that, some of it feels over your head. It doesn't matter what regular people think about it. In trademark law, that's the only thing that matters. So when we ask if something is a trademark, rather than just being something you're trying to use as a trademark and don't yet have rights in, if you name your band The Band, for example, or if you name your burger joint, New Haven Burgers, then it takes a lot more work to turn it into a trademark. And the way we find that out, or the thing that we're trying to gauge is, well, what do regular people walking down the street think? Or what are the people who are in regular times, who are kind of strolling the aisle of the record store, what do they think? Based on the way that you use something and based on what the mark is, do they understand it to be the name of the band? Do they understand it to be the name of the record company or the record store? Is it something that serves as a source indicator that they think, well, there's only one of these, versus, if you pick up a record and it says vinyl on it and you say, well, that's not a trademark, that's just a descriptor of what's going on here, right? And that's true too of likelihood of confusion, which is the linchpin really of almost every trademark dispute. So are the names, are the marks, are the logos, whatever, too similar? Well, we want to know if they're going to create a likelihood of consumer confusion. And it doesn't really matter what the judges think, and it doesn't really matter what the trademark owners think. What matters is figuring out how it's going to work for consumers. So figuring out whether two bands with really similar names, are people going to accidentally buy tickets for one when they were trying to buy tickets for the other? Are they gonna, go to Spotify and type in one and start playing it and say, oh, that's not the one I wanted at all. I didn't know there were two of those. So when we think about actionable confusion, we're always thinking about consumer perception.
And as a consumer protection arm, the registry is a collective database that we could all search. We could go do it right now if we wanted to. If you or I represented a business or a band that was looking to register their name for the first time, we would start by going onto the database and search and see, okay, well, is there somebody already out there using this in commerce? And you either would or wouldn't find something exactly the same, but we might find something similar. So in that case, where something is similar but not exactly the same, are there some best practices that you would counsel a band or a manager who's representing a band to take steps or actions to take or conversations to have?
Yeah, so some of those things you can do on your own, right? You can access the USPTO website. We have Ed Timberlake on the line right now, who is a search expert who's taught a class for us at UNH on trademark search. And if you are a layperson, you may not know exactly how to do a really complex search that'll get those similar marks. So you might only get identical marks. So if I go on and I type in Counting Crows, then I might get only exact hits and not kind of misspellings or slightly different band names or singer names or toothpaste names or whatever it is that's going to pop up, right? So there are different places in the scenario you're describing where you might want to talk to a lawyer. You might want to enlist the help of an expert who can craft that search. There are also services that will do a really complex search for you and send back I'm holding up my hands to show the binders that we used to get in the old days. And I think that you can still get with just tens of thousands of hits that the lawyer reviews and says, 99.9% of these are fine and they're not going to be a problem. But I found 5 potential problems and I'm going to walk you through them, right? So this one is in a completely different industry. This is a trademark for crayons for kids, but you know what? It's exactly the same band name that you want. So you might just want to think about whether there's any potential for conflict there. You might want me to look around and find out whether that crayon company is really litigious or not, right? And you might want to think about how distinctive and how famous the mark is, because if you're going to call your band Crayola, then you're probably going to hear from that company, even though your services are so far apart, right? And then we get into other hits that are maybe closer. So maybe they're selling headphones, maybe they're selling t-shirts, and you want to sell t-shirts that are related to your band, right? Maybe they're doing something related to sound or related to film or in the entertainment industry, and they're really similar. They're a couple letters off, right? So then we want to kind of work through our likelihood of confusion analysis and ask how similar they are, and different things that we look at to try to predict how likely consumers are to be confused. And at the end of the day, some of the practitioners who do this constantly can tell you more specifically how often this works, but sometimes you want to reach out, right? Sometimes you want to pick up the phone and say, would you have a problem with this? Does this seem like it's okay? Do you do anything that touches at all on the music industry where we're planning to be? I think the key point that we're glossing over, though, is doing this at the front end, right? So thinking about in the really early days when you're naming a band, when you're when you're talking to a new musician who's talking about releasing her first album or whatever it is, that's when you want to have these conversations. You don't want to have them after, you're talking to a band who's been around for 7 years and they're really attached to their name and they're kind of expanding and they're starting to get more exposure. And then to say to them, this is not great, guys. You should, now that you're getting bigger, you're going to have to think about changing your name. So just doing that due diligence on the front end can go a really long way.
It's an interesting point because when people are getting their bands together, they're planning on selling merch, they're planning on playing Madison Square Garden, and they're planning on flying in private jets, but they never plan on getting so big that they're going to have a really hard time changing their name. Mm-hmm. And so if you only address it after it's a problem, then you've only addressed it once it's a problem. Try to get as much of this done out of the way up front, I think I'm hearing you say, before it becomes an issue. And that can be tough when you're trying to select something as creative and identifying as your band name. But I think it's a really good point because it starts you down the path of having these really interesting conversations that you need to have with your bandmates from an abstract level while it's still something that you can think about rationally rather than under the gun of pending litigation or a cease and desist order or something like that.
That's so true. And when we're thinking about traditional products that you find on the grocery store shelves, we're thinking about trademarks for apps and businesses where maybe there's a little more detachment, then those entities are probably going to sit down and come up with 20, 30, 40 names. Maybe they talk to a naming branding expert, and then they do that work before they make the choice, right? And I think when you're dealing with a musical artist, that you're missing that detachment. They want something that really feels like them, that's going to be their identity. That's for band names, it's often going to have that right level of cleverness, right? It has to hit a sweet spot. And so I expect that lawyers who work in this industry have a lot of push and pull there when they have to say, I know you're super attached to this name and you have your heart set on it, but I just think it's risky. And here's where I put the risk level.
Well, there's some interesting points in the chat right now. Not surprisingly, most of them are by Ed, attorney/Professor Timberlake. But Kara, who did her turn as a musician in Boston and now helps run a museum that's about to open in Nashville there, says, or she reminds people, you're never going to find your stuff just by doing a web search. A web search is a good place to start, but it's by no means comprehensive, right? And then Ed,
right. He
dropped that search link in there. So if anybody wants to take a spin, in the chat is the link to the USPTO search. He also says before you buy a domain name, yeah, I'd say before you spend any money on any type of branding, marketing, merch, certainly a web site being built, then make sure that you're cleared. I can tell you a war story of my own from my time when I was in the creative portion of the creative arts. We had a band that we thought was really brilliant, and we named the band Spaceman Spiff. And we got a cease and desist letter from Bill Watterson, who famously created the character. and the comic Calvin and Hobbes. And it broke our heart because we loved him and we loved the comic, and we thought that we were paying an homage, and his attorneys didn't much care what we thought. And so we had to change our name to something terrible. Thankfully, we weren't that good and we didn't have much traction at all, so it didn't really matter. But you can only imagine if there is a really popular, really good band, somebody's trying to enforce that trademark because A, there really is a chance of confusion, or probably more likely a chance that they think the two different products are related. It can be very costly, and as Ed points out, it's not all that expensive to have done properly up front, but it's certainly much more expensive to have undone later or to deal with the fallout.
Yeah, and I think on the point you raised about just kind of a general search, it's not just that one is more expansive than the other. It's in some ways that they catch different things. So the comprehensive trademark search is going to find registrations, and users might be really quiet, right? You might be completely unaware that there's somebody else using that name for a bar in Nashville, and there's another one in another city, right? And they have use in they have use in interstate commerce. And you might not know about it until you do that type of search. And then on the other hand, you got your Google search and you got your social media searches and your domain name searches, and those are going to pick up different things. So those might lead you to say, oh my gosh, we're not going to get in trouble for using this name, but we're not going to be able to get the stuff we want, which is the social media handles across every different platform, which is the domain name that would be kind of the logical choice of domain name for us. So that's a kind of different way to think about the real estate that's available to you.
So not all of your uses would be trademark uses, as law defines it, but each of them is going to go into your commercial use. And so since you're looking for brand alignment, marketing alignment, outwardly facing publicity alignment, you kind of have to get those ducks in a row up front before you launch that new project. And so it can be a little tedious. I don't know how expensive it is, but to get it done right, I don't know that you can do it quickly and cheaply. I'll say that. Probably one or the other is possible.
It's all relative, right? Because when you're talking about the difference between doing that search on the front end and making a change later, and I wrote about this a while back in connection with restaurants, for example, right? And there's so many sad stories of restaurants. They choose the name, they get the sign, they print the menus, they start marketing, they set up the website, they're ready to go. And then they get that cease and desist letter like 2 months after opening. And they say, we can't afford to do this all over. Like we don't, to take all of that stuff and destroy it and then rebrand from nothing, throw away the goodwill that we have and the media coverage that we got. That's asking a lot. That's a really expensive mistake. So I think it's a good investment.
It brings up a good point because I think as gals and guys get together to form these bands, your group is a small business. And so this is part and parcel to a conversation I have with a lot of people, which is we should get a band agreement. You should consider filing as an LLC or other options that your state may have available to you. But, your publishing company, well, we don't have publishing. Well, that's not true. Everybody's got it. You're just not doing anything about it. It's just hanging out there. So let's set up a company.
Yeah.
And again, have these conversations at a time where you're all thinking rationally about it. Before the guitarist decided to not show up to a gig, or the lead singer didn't bring his PA system and now you're pissed off. Have these conversations and engage a third party to help you get them down on paper. And one of the bigger ones that I think you're talking about, branding and trademarking go hand in hand with logos. They're not synonymous. They're not exactly the same, but it's probably the biggest use that our industry has commercially of trademarkability, because I know you remind me, song lyrics, probably not registerable as trademarks. Album titles, probably not. Maybe if you title your tour, it could be. But your biggest merch that you're selling, merchandise, is going to have your band's name on it. And so when you're talking about art for your project that has your band's name, your logo, and all these things, have the conversation about what happens if we break up. Who's going to own that? What's the process for something like that? When your band breaks up, does your trademark go away?
Kevin, there's so many things that I want to
thing?
respond to. Completely
I
agree
talk too
about
much.
having
Go.
an agreement, forming maybe some kind of corporate entity, because when you're talking about trademark disputes in the music industry, I don't know if I want to say the majority of them, but a ton of them are kind of intra-band disagreements, right? You have the Doors litigating with Jim Morrison's parents over who has control of the name and the rest of the IP. You have, I think it was the Platters, that case went around and around and around and around. And that was about, you know, who was the listed owner of the trademark, and it was the manager, but it wasn't anybody who had ever performed in the band. And we've had so many bands, like you said, where get rid of the drummer, find a new drummer, rotate somebody through, right? A lot of bands end up including over their lifetime a lot of different people. So the question of who has the ability to use the mark in connection with themselves and their own musical performances going forward after the band breaks up, or after they're kicked out, or somebody leaves, or somebody dies, or whatever, that's a really messy question. I don't think the defaults are even that clean, except to say that if you do apply for federal registration, who you list as the owner of the registered mark matters a lot, right? There's a presumption of ownership that the owner is the listed person. So if you're in a band with 6 people and one person is like, oh, hey, you know, my brother's a lawyer, I'll just take care of this, I'll just register the mark, and then they do it in their name, that could turn out to be a really big benefit for them later that nobody else planned on or understood themselves to be kind of agreeing to.
Or some of us see in proposed record label deals, recording contracts, is this rider or this paragraph that says that the label is going to have access to all IP, including trademark, name, image, likeness, in connection with their need to promote, market, etc., the project that you're putting together. But the language there sometimes isn't clear enough so that it could be argued that they not only have unending, perpetual, and free license for that trademark, but that they actually own the trademark because they're going to do the artist the service of registering those trademarks with the USPTO just to make sure that it's done right so that the protections can be afforded. So that's one way where I think we encounter those things without really knowing that we're dealing with trademarks.
And Kevin, I know you're a Prince fanatic.
Yes,
so
I am, of course.
What led Prince
as
to
you can
change
see over my shoulder. Well, if you're as big as Prince, you can always go by no name at all, and you can change your name to nothing, an unpronounceable symbol. I wouldn't recommend any other band try that. That was definitely playing hardball. Although I will admit to you, in middle school, I also tried to develop a symbol for my name. I put it at the top of my test. I tried to tell my mother that she couldn't call me by my name anymore. It didn't have the same effect, and I'm not sure I was suffering the same slings and arrows that Prince was. But that, yeah, that was an effort for him, as he recorded under many pseudonyms. He wrote under many pseudonyms. But he has hundreds of thousands of works, either partially or finalized, completed, that he either did or didn't want to release. And so he's kind of a unique character in all regards. I don't know that I can use him as an example other than in class. But there are some examples, like, you know, you brought up the Platters, the Misfits in the chat. You know, who tours under the name Pink Floyd, who's allowed to play as the Beach Boys. You know, some people are shocked to see that all these 50s and 60s doo-wop and R&B bands are still touring. Well, the only thing that's still touring is the suits and the logos. You know, they're all replacement parts, so to speak. So, you know, in that regard, it kind of does get to a consumer confusion type thing, because you know, somebody's mom might be convinced that they're going to see, you know, the Spinners or the Four Tops, and then come to find out that it's not the same. Does it really matter? Who knows? Maybe not. There's good argument to be made that tribute bands are going to deliver the product that the people are looking for better than these aging rockers could right now. But that's a different conversation for a different day. I think another thing that is interesting to make sure that people touch on is, okay, you've done the diligence of looking. Maybe you've listed some names that you like that had to get crossed off the list. Now your list is getting smaller. And when you go with selecting one that seems like it's open, you list 2 things that you want to consider. You want to consider searchability and similarity. And to that, I would add kind of a combo of that marketability. And similarity isn't always a negative necessarily, right? Don't be afraid, I guess I would say, to have something that's similar to a registered mark. As you said, somebody's selling, melons somewhere at a market in Los Angeles probably doesn't affect the punk band in Chicago. But what would you say about searchability, marketability, and similarity?
So I think, I listed those in terms of some of the issues we've already touched on, right? But thinking about lessons to be drawn from the Lady A dispute,
Yeah.
thinking about what Anita White says happened as soon as Lady Antebellum announced their new name, was that her results just got buried, right? So that made me think in terms of, it's a pandemic. We're in an increasingly online world, even when it's not a pandemic. So Tom had a great one of these on Tuesday about musicians using Twitch, some of whom were using Twitch kind of as their full-time source of income and finding their fans there, right? So the platforms and the streaming services and the ability for your fans to find you quickly and easily and in a straightforward way, I think those become more important every day. Right. So in thinking about your mark and kind of clearing your mark, thinking about folks' ability to find you and to make sure that nobody's confused. And I wanted to jump back, Kevin, to something you said about, lyrics and merch and things like that. So I've been a little bit focused on the importance of figuring out and protecting and investing in your mark. So I want to say something about all the things that are not necessarily marks, because I think there's a tendency to be really overzealous, right? So we've seen Taylor Swift, for example, applying to register like all these little snippets of her lyrics and getting into disputes over album names. And those things are not necessarily marks, right? A mark is a source indicator. That's a really clear, straightforward thing to say about toothpaste or dog food. And it's a less straightforward thing to say about a performing artist, right? But you still can kind of define what your services are. And there are a lot of celebrities registering their own names for things like appearances and entertainment services. And those things I think are worth doing, right? But when you get too far afield, when you get into every little nickname and catchphrase and things that fans might be interested in using and hashtags, a lot of that is overkill, and it's not really what trademark law is for. So I don't think that's a good use of resources. And it's also really important to focus on use as a mark, using something actually to communicate to consumers, making it big, making it prominent. If it's your logo, you put it everywhere, making it clear that that's a representative of you, which is not necessarily what's happening with a one-off album title or the name of a tour or lyrics. And it's not really what's happening most of the time when you are putting something on the front of a shirt or on a hat, right? That's not telling somebody who makes that shirt. It's just telling you that that's a shirt for somebody who loves the band, right? So that's not the way that you build trademark rights. And you're not obligated to register for all of those different things to say, well, we've got mugs and we've got hats and we've got shirts and we do a little of this, a little of that. We have an app, we have a game, right? You don't need to assert rights in every different area. So I think kind of focusing on that main mark and main use, or those couple of things, maybe the band name and the logo, are really what's key.
So you said the magic buzzword of the day. I want to start big picture briefly, because in our Q&A, Jonah asked, what are some legal pitfalls when you're starting a label rather than a band? And I think almost all of these apply to invention of your brand, creation of your mark, and registration of your mark. It could be a label, it could be a services company, it could be a t-shirt company, a sneaker company. And I think you and Andy always say online, everything always comes back to apparel, right? If you're not in the apparel business or telling the USPTO you're about to be in the apparel business, you're probably doing something wrong. So presume everyone's in the apparel business. As far as contractual things and licensing and things like that go, when you're starting a label company, just to answer his question, I think there's a lot of different areas that need to be consulted, from business to copyright and employment law. But specific to trademarks, I think your brand as a label, your brand as an artist, or your brand as a management company for that matter, are all at stake. And so all of these lessons would apply to those. But you said the magic word today, which is Lady A. That's kind of the biggest thing that you and I were talking about in regards to this in the last year. And somebody in the chat asked, what would be, where's the thin line between policing, maybe over policing, and that PR, right? There are legal rights that you have, and you may be just in enforcing those rights, but trademark doesn't live in a vacuum, and certainly business is across the board. So let's unpack that story a little bit, and I'll start with my recent interaction and my own confusion, and then I'll get out of the way and you can take people through it. A client of mine is, or did last week, play a show in Nashville, and she was on, it's a virtual bill. And she was on at 9, and I think it said Lady A was playing at 6. And I thought instantaneously, this is so great. I don't know if they're going to be in the same room, but I'd love for them to interact, because I'd love to hear from Lady A, Nita White, what her side of the story is. And my client is very friendly, very gregarious, and she gets people to open up. And so I had thought for a couple of minutes, maybe I should ask Maggie to pump just a couple of questions her way. And then I realized she's not coming from Seattle to Nashville. It's obviously, the new Lady A. And I'm somebody who should know the difference, but I had been completely fooled. Would it have gone so far as for me to pay some money and log in? Probably not. I would have realized beforehand. But I couldn't have been the only one that thought it, at least fleetingly. Yes, Ed says in the chat, actual confusion. Yes, and I would testify if I needed to. So that likelihood of confusion, or that actual confusion, is the nexus of what are those two competing disputes. And I think you and I can do a little role play to walk people through. But let's start with the beginning. Lady Antebellum is to change their name for all the reasons that we understand. And they say, we've secured all the social media handles, and we're going to change our name, and by tomorrow, poof, we are Lady A. And then somebody in Seattle raises her hand and says, what? So go, I guess.
Yeah,
There's so much.
This past summer, right? I think people probably know the story in broad strokes. So it's Black Lives Matter is huge, is all everybody's talking about. We have the Washington football team, after 1,000,000 years and 1,000,000 lawsuits, says, oh, you know what? We're finally going to do it. We're not going to be the Redskins anymore. Aunt Jemima, Uncle Ben's, all of these trademarks with a lot of history to them, and the arguably a lot of value, a lot of monetary value. Companies are finally ready to let go of them, to make that statement. So this band shows up and says, oh, us too, we want to be allies. We want to join the fight for social justice. We don't want to have a racist name anymore. We've seen the light. And our new name is Lady A. And so I would say there was like a day or two of good press coverage, or at least medium press coverage, like, okay, good, we're making some progress, before everything flipped. And everybody was like, oh, hey, so you're announcing that you're allies, and you're going to express that by silencing and stealing from a Black woman artist who's been around for decades, right? Decades. That's how you're going to handle this? So the band reaches out to Anita White, who is a musician, a Black musician who's been performing and touring and releasing albums as Lady A for many, many years. And they said, let's get together. Let's see if we can work it out. And the band feels great about it, because the band has 3 trademark registrations already for Lady A. And in fact, those trademark registrations are incontestable, which makes them really hard to challenge, right? So that means nobody said anything about these registrations for more than 5 years from the time they were registered. So they're like, don't worry, I'm sure we can work together. And they have this video call that they post about, they tweet about, and they say, we're excited to share, we're moving forward with positive solutions and common ground. And apparently they offered coexistence, right? So you don't have to change your name. We are also going to be Lady A. We feel good about the prediction that nobody's going to be confused. It's not going to be a problem. We'll give you $10,000 toward your legal fees. And we're going to engage best efforts to help promote you. So this could be really good for you. We're going to, pretty vague on what that means actually, but we're going to help you get more well-known. We're going to help you kind of build up your career. So isn't that great? And then they send her a draft agreement, and she's really not impressed by it. And she's like, I think I can do better than this. I don't think this feels right to me. And I think probably popular reaction and maybe lawyers on social media and everybody else saying this isn't right led her to get rid of her pro bono counsel. She's now represented by Cooley, which is a great big IP firm, or firm that does good IP work. And they came back with their own counter proposal that included $10 million. And she said $5 million would be for her rebranding, and $5 million would be for Black Lives Matter, for them to support the movement and to support other artists. The band called that number unconscionable, and they turned around really, I think within a week or so, and they sued for declaratory judgment, right? So it's not, see the chat says white privilege at its finest, right? So they said, yeah, we're gonna talk a big game about supporting Black Lives Matter, but when it comes down to it, we feel like we have the legal right to do it, and so we're gonna do it. We're gonna stomp all over her. But again, declaratory judgment jurisdiction suit is not to accuse her of infringement or to say that she can't use the name. It's just to have a court say, to kind of affirm the validity of their registrations and say there's no problem with them continuing to use the name. So of course they sue in Tennessee. And then a couple months later, Ms. White sues the band in Washington State, right? So she actually sues them for infringement. And she says, you have some registrations, that's nice. But guess what? I have priority. And in fact, as we were talking about earlier, I have common law rights. And I've been using, since the 1980s, I've been performing as Lady A. I've been touring the country. So it really wasn't just the Pacific Northwest, according to this latest filing. And she's toured internationally. She's done a lot of performances in Europe. She's released albums. So she's really detailing all of this use that looks like trademark use. Now, again, there are some kind of, I think, existential questions about whether giving yourself a name and performing is enough for trademark use. So priority usually ends up being a really factual, a really fact specific and fact intensive inquiry where we say like, well, what kind of publicity was there? How much marketing was there? Show us the, show us the billboards and show us the emails that went out, show us the banners and the, how broadly were you marketing and how exactly were you using Lady A? Was it more like just your name as a person, or was it more like a brand that you were building? Because if you really can show that it was a brand name and it was a trademark kind of use in connection with musical performances, and it was nationwide, or even if it was more limited, then you're going to be able to show prior rights that are going to trump the rights of the band. Again, even though the band does have these specific registrations. When I dug into the specific registrations, and I tweeted about this a while back, so I ended up talking to a lot of reporters about this case. When you go to the USPTO website, you can pull up the whole file wrapper and you can see the specimens. The specimens are not super impressive. They kind of look like our name is Lady Antebellum, and sometimes we call ourselves Lady A. It's like a nickname. Like this is some text from our website saying, hey, Lady A got another award. Hey, catch Lady A tonight on Saturday Night Live. And then the screenshot is Lady Antebellum, right? And they've got use kind of in connection with their merch store, but it's not really extensive use. That said, it's really hard to challenge all that stuff when you have incontestable registrations. So some of that is not going to matter a whole lot. But again, I think if it comes to the point where a court is kind of lining up those sets of facts and thinking about who has priority, who has superior rights, whether it's going to be one or the other, or whether there's some kind of coexistence that we can reach, a lot of that is up in the air, but I think you can tell which side I come down on. On top of all that, right? This is like a huge string of PR mistakes, and this band just seems like it's shooting itself in the foot, right? You have a massive public outcry saying, why are you silencing this woman? You have a band that is really in a prime spot to choose any name, right? You've got the national attention. You could say, oops, we made a mistake. 2 weeks later, 5 weeks later, whatever, we're telling you our new name now. And it's something that is not antebellum and not an abbreviation for antebellum and isn't even reminiscent of our really maybe problematic past. It's something else, right? So they could do some good there. And instead, they just are going to insist on fighting this fight. So I think that highlights, there's so many takeaways, Kevin, we can talk more about, but I think that really highlights the two pieces, because you can be legally in the right and you could be morally wrong, and you can be wrong in terms of what's going to earn you fan approval, what's going to be meaningful to the fans that care about your music and that care about you as a band, what's going to feel right to them.
And you have to always remember, if you're in a band or steering a band, notoriety and goodwill are not necessarily the same. Either one of you will get you protections for your trademark, but they may not sell tickets. And the old adage that all publicity is good publicity, I don't know if that's necessarily true specific to trying to do right vis-a-vis social justice and ending up shooting yourself in the foot. But I agree, they could have pivoted. They didn't. But to play the Lady A advocate role, the declaratory judgment filing is really more of an opportunity to ask the court to recognize the propriety and the rights behind their filing and their registration, more so than it is asking Anita White to come out of pocket for any damages that they're going to ensue or any legal fees or anything like that. And they're certainly not trying to force her to change her name. In fact, I know a lot of people, when this happened, said, what's really the problem? Nobody's ever heard of her, and now everybody's talking about her. Well, again, talking about somebody and buying tickets to their show are not the same thing, but it's tough to put your values on somebody else. And they said, we'll give you 10 grand. They came back after she hired new counsel with 10 million. And maybe it was a play for a bunch of money, but maybe it was a number that they knew would not be accepted because she didn't find it to be an acceptable result. That said, you're not supposed to go for declaratory judgment until you've already tried to work things out here. And they take that letter back to the court and they say, hey, look, they're asking for something that's totally unreasonable. That means that we're going to assume there's no chance for us to work this out, which maybe is or isn't reality, but we're well within our rights to go to the court and get this declaratory judgment. And then we're going to hold that anywhere else you try to take us. We're going to take that to Seattle if we have to, and we'll take it wherever else you're going to try to bring us into court. But the two of them are not really enforcing the same exact rights. Right? You've got common law, more localized rights. Yes, she was on tour. And I guess now that you can publish things on Spotify, anybody can be national or global for that matter. But in the chat, someone says, well, who can afford to pay expensive lawyers longer? Sometimes these disputes end up that way. Who will buckle first? There could be a narrow path to solution for both parties. But it seems right now we've got competing lawsuits that will probably have to be consolidated at some point somewhere. But are each of the parties looking for the same thing right now, or is there a way for each of them to walk away from this with a win still, legally and from a PR perspective? What do you think?
Yeah. Are each of the parties looking for the same thing? Not exactly, although they both want the right to use Lady A. I would say White expects to continue using that name. And then the question is, can she keep this band from, burying her in the search results and from kind of taking over, so that where once people could find her, she becomes unfindable and it actually harms her career, right? Or where just the kind of confusion you talked about, which is often harmful to both parties, whichever direction it goes in, right? We care about forward confusion and we care about reverse confusion. So anytime consumers are misled or consumers are kind of have their time wasted because they go down the wrong path, that's not great. That's something that trademark law cares about. In terms of the band's goals, I think probably true to their original DJ action, they don't want to force her to change her name, but they want to kind of make this go away, and they want their choice validated, vindicated, to say, you know, we chose a new band name that we think is inoffensive, but is similar enough to our old band name, and in fact is a nickname known to fans. So we want to go ahead and keep using it. And that band is pretty big, so that they're kind of like, clear the path for us so that we can do that without really giving up something that we care about, something substantial.
So when it first hit, not their name change, but the dispute, the first thing I did was go to the streaming services and type her in and see, can I find her? There are lots of musicians that, contrary to popular belief, are not published online. They're not streaming. They play local gigs. Maybe they tour regionally. Maybe they even have a trunk full of CDs, or their mom has one in the attic, but maybe they're not available online. Doesn't mean that they're not in commerce. Doesn't mean that they don't have protected names, because they've spent that time building that goodwill and they've got that community. But I found her right away on Spotify, Amazon, Pandora. And so, I don't know who at their management team was in charge of trying to figure this out before announcement, but in my mind, from a PR perspective, somebody dropped the ball. Now, if you told me, well, we asked the lawyers and they said we've got registration everywhere, so we should be good. Okay, I guess you're right, and you'll probably win, but what does it mean to win, I guess, is the biggest answer. And this year, more than ever, I think you've got to start realigning those wins. So are they after the same thing, to answer my own question? Maybe on paper, but I don't think the goals are exactly the same. And I think now, after the PR disaster, some of those goals may have changed too.
The International Trademark Association has an annual meeting, and you can kind of pick up on the themes, and this is really like in-house counsel from some of the biggest corporations in the world. And the conversation this year was a lot about values and ethics, and how much do consumers really want you to kind of stake a claim, to stand up for what they think is right, or to not remain silent, versus some consumers who are really vocal about the fact that they want companies to be neutral. They don't want to hear what companies think. They're offended by that, whether you agree with them or they disagree with them. And so to hear kind of the brand management people talking about walking that tightrope was really interesting. But I think one obvious thing that comes out is that if you're gonna do that, if you're gonna make a stand and say, our brand is passionate about global warming, and here are all the things that we're doing to fight global warming, and here are all the ways that we express this, and the things we're doing to make the world better. Once you take that stand, then you have to be consistent, and you have to avoid looking like a hypocrite, right? Because if it comes out that, everybody in your C-suite has a private jet and they use it every weekend to go wherever they want, then you're gonna look really foolish, and you're gonna regret having spoken up at all. So I think what's going on with this band, is really a microcosm of that.
So just before we wrap up, a couple rapid fire. A couple people have asked some similar questions in regards to expiration dates, or abandonment, or renewals. And can you talk about that process and things to keep in mind if you are a register and you keep it around for that long?
Sure. Trademarks can last forever. So as long as you're using something as a trademark, or you're using it in interstate commerce, you can maintain that protection forever. There's no expiration date, right? When it comes to maintaining a registration, there's paperwork that you file every few years. You sign something that says you're still using the mark, and you send in a new specimen to show exactly how you're using the mark. So that's something that your lawyer can help you with. Or if you're pro se, you might just get an email notice saying, that this deadline is coming up, or you have to stay on top of those. I did see somebody asking about abandonment. So abandonment is when you stop using a mark and you don't show an intent to resume using the mark within a certain period of time. You don't have a really solid excuse, like we were trying to use the mark, but nobody was buying the stuff because it was a pandemic, or one of our suppliers was in Cuba and we had this embargo and, you know, we weren't able to get this component for this period of time. So there may be excuses. But where abandonment becomes really interesting, and frankly, I think a little bit of an area where the law is unsettled, is with these companies that are affirmatively dropping certain marks, right? So for example, the Chief Wahoo mark in Cleveland, there was the big announcement that we're not going to put this offensive Native American mascot kind of based on a stereotype. We're not going to put it on the uniforms anymore. But what was quietly going on was the team saying, you know what, we're still going to license it for merchandise, because then we still, you know, because there's still people who want it, but also because we don't have to worry about somebody else picking it up and running with it and saying, well, you're not using it anymore. You abandoned it. So now we can use it, right? So we still will maintain those marks in some way. And this is something we're already seeing. We're seeing applications to register Aunt Jemima and applications to register Redskins and all these other kind of attempts, which put the former owners in a really weird spot. Because again, you don't want consumers confused. If you walk into a supermarket and you see something that says Aunt Jemima, you probably will be confused, right? You could be deceived because you used to buy that brand. Maybe you don't follow the news obsessively. Maybe you don't know that it's no longer from the same source. On the other hand, if you're the brand that said, we have really come to terms with how offensive and problematic this stereotype, this image, this name is and has been for the 100 years that we've been using it, and we're finally never going to use it anymore, can you then turn around and sue somebody else for using it? Do you have motivation to do that? Do you look ridiculous, right? And is it your responsibility? Like, are you going to spend money on that when you're not the user of the mark? So there's some really interesting issues with all of that. So Lady Antebellum is a great example. Could somebody pick it up and use it and then say, well, look, nobody else wants it, we're going to take it, right?
Can you and should you are not the same thing.
Right. You have a
Could
doctrine
they?
of residual goodwill that
Maybe.
says even if the old user isn't using it anymore, if consumers still are aware of it as a trademark connected with a particular source, then you can be stopped from using it.
Right, and that goes back to the thing that we talked about at the very beginning, because of the way that the trademarks are actually created. The registry is just that. They don't give you the rights. They only recognize the rights, and it's more paperwork than anything else. It's up to the business owner and the mark owner to engender that goodwill, or badwill, I guess, if it's notoriety that you're after, to create that source identifier. And abandonment is not as simple as saying we're no longer using this anymore. I don't know what would happen if another band decided to change their name to Lady Antebellum. From a legal standpoint, PR probably wouldn't be good, but you know, who knows what people are after. I saw one really interesting cue in the Q&A similar to that. I think I know the answer, but Terry Sawchuk asked, if I left my trademark run out and then re-register years later, is the creation date still recognized by the original trademarked date? I'll let you answer that question, but I'll only say nobody in the chat that does trademarks is comfortable with trademark as a verb, particularly Mr. Timberlake. And so I'll tell you, we don't trademark things, but we get trademarks. We have them recognized and registered. But is there such a thing as it running out? I think you answered that. And does the date always go back to the original?
Yeah, hopefully Ed will correct me if I get this on the really kind of esoteric registration stuff. But if you're lucky, nobody else jumps in the meantime and starts using it when you paused, or if your use has been continuous, then you still have those common law rights that date back to your earlier use, and you can still assert that earliest use in interstate commerce, and that will be connected with your registration. So if you forgot, if you missed a deadline, and your registration lapsed, then you'll apply again, and you'll have a later registration date, but you can still put that earliest use in commerce date on there.
So there are other really interesting topics. I don't know that we have time to get into them in a way that will do them justice, but I want to mention them in hopes that we can hook you in to do another. One is hip hop artists using really global brand names as their own name, right? Gucci Mane is one that stands out. And the other is sound marks, and how Mr. Pitbull recently was awarded registration for one of his trademark ELs. I would love to see if we could rope you in for a part 2 to, now that everybody's got a good basis in trademark, to launch into those sound marks and the combination of branding from a global perspective, and those artists that very obviously are not using their own names, but are adopting these luxury brand names. What do you say?
And I'll just say real quick, and I tweet about this stuff all the time, but Julie Zerbo at the Fashion Law has a lot of great posts about Burberry, who shut down one musical artist who had Burberry in his name and now has come after a different one, right? And then as a kind of as a case study, as opposed to Gucci Mane, which who's been able to coexist with Gucci and in fact ultimately kind of do some partner on some collaborative stuff. So there's a lot that goes into those decisions by brands. And I think both from a legal perspective and a PR perspective, right? How strong are the rights if we want to enforce them against this artist? And then is that even the decision that we would choose to make?
And does in-house legal make that decision, or does marketing PR make that decision? I think it all comes down to brand alignment and being true to the history of the brand and what goal you're setting forward for yourself, whether it's a band or a fashion brand or a commercial brand, cars, whatever it may be, apparel. I think we're running out, and so I don't want to get too much into that because that's an hour into and of itself. But
I think you have to end with the full yell. So can you do that?
About a year ago, my wife and I each gave the other Pitbull tickets for our birthdays. So I'll let you leave that up to your own imagination, whether or not I can intimidate Pitbull.
Awesome.
It's a hell of a show. If nobody's seen it, you should go. Anyway, Alex, thank you so much for letting us intrude. I hope you have a wonderful holiday. I will see you online in probably 20 minutes because I'll have new questions that you haven't yet answered for me. And Tom, I want to extend my gratitude to you also around this time of year, man. Not just this series, but everything that you've done to bring me into the fold. I really appreciate it, man. I love the way you do things. I love the people that you bring to it. And I hope we were able to do you justice today. I really had a good time with it. So thank you both very much.
Thank you so much, Kevin and Tom, too. It was a blast.
Well, on behalf of the audience, let me say thank you to you two rock stars. The chat speaks for itself today. They're asking for not only part 2, but part 3 as well. So I have a feeling you left plenty of, you got a lot of pent up demand, shall we say. So yes, to the audience, there will be at least a part 2 at some point in the new year. I want to thank everybody for their participation. I want to remind you, we have 2 more events next week, Tuesday and Wednesday. Tuesday, we're featuring a walking encyclopedia of music named G. Brown, being interviewed by Michael Jensen. These are the 2 most well-connected celebrity journalists or PR people I've ever heard of or talked to. Unbelievable. And then on Wednesday, we wrap it up with Lee Trink and Ralph Simon. Lee Trink is the CEO of FaZe Clan, which is one of the most exciting gaming platforms. Anyway, folks, I thank you for being here. Be nice to one another, wear a face mask, and we will see you next week. Thanks again, guys.